Hi, I'm Ronald. I'm a lawyer, advocate, educator, speaker, writer, thinker. In this episode, we'll look at the law of trademarks. Now, trademarks generally is about protecting fair trading. It protects the time and effort spent by a business or person in building up a particular sign or logo as a trademark of the business or brand, and that targets unfair competition from competing businesses or traders who seek to take a free ride on the goodwill or reputation that the owner has acquired for its goods or services. There are generally two branches of trademark law. One is passing off, focuses on protecting goodwill. The second, infringement actions under trademarks legislation, which focuses on protecting the right to use one's own marks. Passing off, the law of passing off. For an action of passing off to succeed, the claimant must show generally three things: goodwill, misrepresentation by the wrongdoer, and damage. Now, for goodwill, the benefit and advantage of the name, reputation, and connection of a business in terms of bringing in customers is the goodwill. For example, how a brand name or logo attracts customers to a business. The claimant must then show that the mark or get-up is identified by the public exclusively with the goods or services of the business, not necessary for the members of the public to actually know the name or identity of the claimant as a manufacturer or supplier. Misrepresentation. The claimant must show proof that the wrongdoer's goods or services were held out to be or connected with the claimant's business, thereby giving rise to confusion. Respondent, the alleged wrongdoer has to be found, will be found liable even if there was no intention to deceive or mislead. Um, Usually the question would be whether ordinary sensible members of the public would be confused by the representation of the alleged wrongdoer. Likelihood of confusion usually would be sufficient. And relevant members of the public would be a substantial portion of a group of persons who are probably purchasers of the goods or services in question. And there would be, of course, various factors that would have to be considered in this analysis. And the claimant must also show damage suffered. Uh, a real tangible risk that goodwill would be damaged is also needed. Now, separately, any person may apply for and own a registered trademark under trademarks legislation. Registration will give the trademark owner a right enforceable against third parties, and such a mark can then be protected both under trademarks legislation as well as the tort of passing off. Generally, a trademark would be any sign capable of being represented graphically, which is capable of distinguishing goods or services dealt with or provided in the course of trade by a person from goods or services so dealt with or provided by any other person. Usually, trademarks comprise of one of the or more of the following elements: a word with a logo, or a word together with stylized letters. Nowadays, there are some interesting new kinds of marks, but we will not go into that in detail as it varies from jurisdiction to jurisdiction. Now, the applicant for a trademark registration must have used or have a bona fide intention to use the trademark in relation to the goods or services set out in the application. And it's important to understand that trademarks are distinguished from brands which do not enjoy protection. The mark is the one that enjoys protection, although sometimes it may also have a substantial overlap. Now, generally, trademarks registration would be refused if it does not fall within the trademark definition in the legislation, or is devoid of any distinctive character, or it consists exclusively of signs or indications which may serve to designate the kind, quality, or quantity, or intended purpose, value, geographical origin, time of production of goods, or of rendering of services, or some other characteristics of the goods or services. And it may also be refused for consisting exclusively of signs or indications which have become customary in the current language or in the bona fide and established practices of the trade. Now, whether or not a trademark falls into one or more of these categories for a refusal is considered with reference to the goods or services contained in the application. So it really is quite fact specific. Generally also, a trademark will not be registered if it's identical with an earlier trademark and the goods or services for which the trademark is sought to be registered are identical with the goods or services which the earlier trademark protected, or it is deceptive as to the nature, quality, or geographical origin of the goods or services. Now, a successful registration of a trademark would accord the owner the exclusive right to use the mark in relation to the goods or services in respect of which registration was made, and of course for the duration of the registration of the trademark. The trademark owner may also bring an infringement claim against any person who does any of these without consent. Use the sign, the mark, and the cause of trade, which is identical with the trademark in relation to goods or services which are identical with those for which it is registered, or in relation to well-known registered trademarks, uses a sign similar to the trade mark in relation to goods or services not similar, and there is some other factors including likelihood of confusion on the part of the public from such use, and there would be damage. And so generally for trademark infringement, the remedies that one could obtain would be injunction, a court order restraining the infringing party from continuing further acts, a monetary award, damages, compensation for losses suffered, or an account of profits, that's recovery of profits enjoyed by the infringing party, or statutorily prescribed damages, or another possible remedy is the erasure of the offending sign, and finally, seizure, impounding, and destruction or disposal. Thank you. Be smart, be brief.